Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
Many federal employees also serve as military reservists. If they are called to active duty, they are entitled to certain benefits, including differential pay under the Uniformed Services Employment and Reemployment Rights Act. A recent Supreme Court decision clarifies how those rules apply in times of declared national emergencies. Joining me with more details is partner and CEO at Tully Rinky, Michael McComber. Mr. McComber, thank you so much for joining me.
Thank you for having me today.
Well, the Supreme Court just released a decision recently called Feliciano versus the Department of Transportation that has some potential impacts for federal employees who might also be military reservists. Can you give us a quick summary of the case and the decision?
Yeah. So Feliciano dates back a while now. There's a claim for what we call differential pay. So federal employees who are also military reservists get called to active duty from time to time. And the provision for differential pay is a benefit that federal employees enjoy that will allow them to make up the difference between their civilian pay and their military pay if their military pay is less. These decisions there's a lot of benefits out there for federal employees that are also reservists. This is just one of the many. And there's been some questions in the court as to who is entitled to differential pay. Now, the way the regulation reads is that it is military members who are called to active duty in support of contingency operations. And it was that language in particular that was what the court was interpreting. So for a while now, and Mr. Feliciano's case was one of them, the court was denying benefits because his orders, he may have been called to, support his local unit as opposed to being called to Afghanistan or Iraq or Iran or wherever else in the world they may have been called to. And some of the agencies have been denying those benefits. They're saying, look, listen, you're going right down the street. That's not in support of a contingency operation. And the way the Supreme Court ruling came down is that, ultimately his orders were clearly in support of a contingency operation. But they said, the analysis more or less stops there because by him going, I'm being a little facetious, but by him going across the street to support his local unit, that's actually freeing up the spot for somebody else who might be going overseas, who may be going to a more hostile operation or things of that nature. So in that case, the regulations are quite clear. All of those orders are in support of a contingency operation. And almost all military orders, I think since 9/11, have been in support of a contingency operation in one fashion or another. So ultimately, the Supreme Court's decision clarifies it to make it a lot easier for federal employees who may be called to active duty as to whether or not they're entitled to those benefits, the differential pay.
So what is the impact for agencies where these federal employees currently serve? Do they have new responsibilities or different administrative processes that they will have to follow?
I don't think the administrative process should change. I mean, a lot of them have administrative processes to apply for these benefits when they're called to active duty orders. Generally, you submit a copy of your military orders and it'll get paid. But it should make it a lot easier because now there's no question as to what orders qualify and what don't. And that's been the rub since the predecessor case. I said this has been going on for a while. There was a very famous case, O'Farrell, about 7 years ago, 5 years ago. I don't know. I'm forgetting my dates at this point. I think it was 7 years ago. I want to say 2018. And O'Farrell was one of the early cases when it came to differential pay. So this is clarifying a lot of that case law out there. The agency should be well aware of their obligations here. If anything, it's providing more clarity.
Does this open a window for retroactive claims if folks have been denied in the past or didn't think that they were called under these circumstances? Could they now apply for that differential pay?
100%. One of the things we love most about USERRA is the Uniformed Services Employment and Reemployment Rights Act, as we all call it, USERRA. There's no statute of limitations. So the only arguments against that is the one which we refer to as latches, which is the legal principle of waiting too long. that could be 10 years, 20 years, 30 years. Courts have gone way back in time. So as long as you still have copies of your orders or your records, or we can obtain them, a lot of times we, as a law firm, when we represent people, we'll submit a military leave request. We'll get copies of their leave and earnings statements and their military records and compile the information for them. It takes time. It can take 6 to 9 months, but all that information is accessible.
I'm speaking with Michael McComber. He's the partner and CEO at Tully Rinky. So let's revisit not retroactive claims, but current claims. President Trump has declared many national emergencies since he's taken office. How does this impact folks who just may be on a regular reservist rotation or somehow or other are called to active duty now? Would this provision apply?
It may. If their orders are in fact in support of any kind of contingency operation, if they're called to active duty, I'm not going to break out the crystal ball and say whether or not there's going to be more or less. That's a little hard to predict, but anyone who is called to active duty, may be entitled to that differential pay. I do want to clarify one thing. It's per calendar year. So if somebody were to be called up in, say, November, they would then be able to get an additional 22 days, assuming they used up all 22 days in 2025. They would then be able to apply for an additional 22 days in 2026. So it's always based on the calendar.
We were talking about differential pay, but you just said 22 days. So help me understand that application.
So let's just say, I'm going to make easy math. I make $100 a day working for the federal government. I make $50 a day working on my military orders. I would be entitled to that differential, the $50 differential there. And that would apply over the duration of 22 days. So again, simple math, that would be $1,100 that I would be entitled to per calendar.
Got it. So what impact does this have then on reservists? How are they going to find out about this change in definition? How do they know about their new rights?
Well, thank you. Thankfully, with these types of conversations happening. So I want to thank you for bringing awareness to this. I think the biggest hurdle that I think a lot of federal employees face is just not knowing this is a benefit you're entitled to. This is no different than health insurance. It's a benefit you may have. Go take advantage of it. Go claim these benefits. If they're there for you, you might as well claim them.
This seems like the Supreme Court offered a decision that clarified the language in the application. Are there other areas of federal employment law that you think could benefit from similar clarity?
I don't know if we have enough time today to cover all of that.
I have a few minutes. Go ahead.
You know what, though? I will say there has been some rather good decisions coming out lately when it comes to employment law. There was a recent discrimination claim, Title VII claim. I think the case name was either Amos or Ames. I'm mixing up my vowels there. And that was a very interesting decision regarding what some people refer to as reverse discrimination. So the court has been pretty active when it comes to clarifying what employment issues in the federal government and in just the broader spectrum.
And so just to go back to you, Sarah, for a minute, if someone is serving as a reservist, are there counselors in their unit that they could talk to if they think they want to process a USERRA claim?
So a lot of units, a lot of military units will have legal aid or, the equivalent there too. They do provide a ton of information about that. If people have questions, we also publish a lot of information on our website as to what types of information you need in getting those benefits. So they can certainly look, at tullylegal.com. We have a lot of information out there regarding military leave claims. We also make it very easy to help clients if they want assistance in applying for those benefits. We basically do a lot of the laboring or at no upfront cost to the reservists there.
Well, I've been speaking with Michael McComber, partner and CEO at Tully Rinky. Thank you so much for joining us and bringing this case to our attention.
Thank you.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.